about procedures today. Seeing none, we'll go ahead and get started. Counsel for the appellant, when you're ready, you may proceed. Wow, we have background music.
That's my walk-up music. Good afternoon, may it please the court. My name is Stephen Zansberg. I'm bar number 26634, and I represent the defendants and the appellants. The district court erred in denying the defendants' special motion to dismiss because the plaintiffs did not meet their burden of establishing a reasonable likelihood that they could prove through evidence, present and produce evidence required to prevail on all three of their libel claims. On the first claim, the claim of libel per se, for statements number 1 and 3, as we've listed them in our opening brief for convenience, in which the defendants characterized Ms. Datko's call to action post, as we've been referring to it, and which also the article included the entire post verbatim, and it was recited in the second paragraph of the article. There was no showing of material falsity, or that material falsity could be proven. In fact, the district court found only that it was defamatory, not false. And it can't be found to be materially false because the article, as I've said, must be construed as a whole, and it included the verbatim text on page 6 with a caption underneath saying, "This is what we characterize as a call to record students." And it was also, again, immediately after it was so characterized in the first paragraph. So accompanied by both the plaintiff's own characterization of the posting, the text, and the defendant's characterization, plus twice reproducing verbatim the post itself, leaves it to the public to decide which characterization is accurate or correct. And the reader could independently evaluate the full text of the plaintiff's statement and determine which was the more accurate characterization of what was conveyed. Maybe not what was intended, but what was conveyed and what a good number of people reasonably understood it to convey.
Was that language ambiguous?
We don't believe it was ambiguous. My clients did not construe it as ambiguous when they read it and characterized it and published the characterization of it.
But when you're publishing something about a post that's 42 words and you have an article that's 5 pages long, isn't that susceptible to some sort of ambiguity and a different interpretation?
Well, clearly it's susceptible to a different interpretation because the plaintiff notified us after it was originally published that she had a different intent. At the time of the original publication and even after receiving it, my clients did not believe it was ambiguous, and they saw a number of other JKF parents who similarly construed it as a call for recordings and offered such recordings or said, "I'm sorry, I don't have such recordings." But to the extent that it's ambiguous after being notified of an alternative presentation, the case law is clear that adopting one rational interpretation of a document that is ambiguous negates actual malice as a matter of law. I didn't get to actual malice as to this, but there was absolutely no showing, no evidence proffered by the plaintiff in support of a showing of actual malice. The only evidence in the record is the uncontested sworn statements of my clients that at the time they published this information, they had no doubts whatsoever. The only, quote, evidence that plaintiff proffered in support of the burden to make a showing of being able to produce clear and convincing evidence of actual malice was the fact that these were seasoned professionals and they should have known that it was wrong. And that is not the stuff of actual malice. Similarly, that there was ill will or bad motive, that Ms. Dunn harbored bad feelings towards the plaintiff and her organization. But time and time again, as our brief points out, and this court held in LSS versus SAP, ill will and Ill will and bad motives toward the plaintiff are not elements of actual malice.
Let me ask about that for a moment, because so in the LSS case, it's not necessarily indicative of actual malice, but in that case, it was parties that were like parents that were in a parenting dispute, and there was a lot of evidence of animosity between them that I remember, as the author of that case, that the division concluded that could help to establish actual malice at trial. How does that work in a circumstance like here, where you're not dealing with parties who are like firsthand observers of something, where it may be evidence that they lied about something? I mean, here we're talking about sort of taking a step back from that and reporting on something. How does that whole framework apply in this circumstance?
Thank you, Ron. Well, in addition to LSS versus SAP, I would note that on page 20, where we cited it in our brief, on the set of cases that throughout the land hold ill will and a desire even to harm the plaintiff is not actual malice. It has to be a desire to harm the plaintiff through falsity. And that's what Garrison versus Louisiana says. It's only knowledge of falsity or actual serious subjective doubts as to truth. And those cases
Counsel, what about a reckless disregard towards what's true or not? You can also meet the standard that way. So can you talk to me about that?
Sure. Reckless disregard of the truth is defined in the case law and in the Colorado jury instructions. I think it's 2213, but I may be wrong about the number, as having actual knowledge of a high degree of or a high degree of awareness of probable falsity, or having entertained serious subjective doubts as to truth. Both below and before this court, counsel has mistakenly argued that reckless disregard is an objective standard, that a reasonable person would know or have reason to doubt the truth, and that is entirely not the case. And the jury instructions, which I'm responsible for,
but
for
even
that
if it's
committee,
if it's a subjective standard, and you have tweets saying that this is an awful group and things along those lines, how does that not meet the subjective standard? You know, that Dunn was making these remarks.
Well, it's the difference between common law malice and actual malice, which, by the way, doesn't appear in any of the Colorado jury instructions because it's a confusing term, because juries confuse it with common law malice, meaning ill intent or bad motive or desire to harm. And we're not contesting that Ms. Dunn authored several things that indicated she did not think very highly of this group, including its anti-LGBTQ positions. That's not contested, but that's not actual malice. Actual malice is either knowledge of falsity or a high degree of awareness of probable falsity, and it is entirely subjective. And so the state of mind of the defendants is what matters, and the only evidence before the court is the sworn testimony of all of the defendants who worked on this piece. Plaintiff made the decision not to test that evidence, not to take depositions, not to look for reporters' notes or in some way say, oh, they knew this was false, but they published it anyway, or they had a high degree of awareness of probable falsity. There is no evidence that contests the only evidence in the record on actual malice. Unless the court has other questions at this time, I'd like to reserve the remainder of my time for rebuttal.
I actually do have questions, and it has to do with the limited public figure. I know that the trial court did address that. So let's say that we take that out. What would that look like in terms of your argument that it's per se barred? Is that something that we would decide, or we would remand to the lower court, assuming that we agree with you? That issue has been fully briefed before this court. I don't see why, and the
evidence is undisputed that Ms. Datko and her group had on multiple occasions appeared on media outlets. It was argued below, but ignored by the trial court, as well as other issues. But that issue is fully before this court and has been fully briefed. It's a question of law for the court, whether or not, particularly on undisputed evidence, whether a plaintiff is a public figure or a private figure. And the fact that Ms. Datko and JKF are limited purpose public figures who had voluntarily injected themselves into multiple controversies about Jefferson Public Schools and its policies negates their ability to bring their second and third claims.
Okay, thanks.
Thank you, counsel. Okay, counsel for the appellee.
Thank you, Your Honor. My name is Scott Gessler. I represent the appellees here. Along with me at counsel's table is Mr. Jeff Blue. I'll just dive into things without an introduction with the court's permission. Let me talk about the actual malice. So actual malice can be proved by circumstantial evidence. Courts do that all the time when they look at state of mind, whether it's intentional or reckless. That's nothing new. Courts are quite capable to do it. And I think what the appellant is essentially arguing is saying, look, the only evidence that matters is whether or not we confess to intentional or reckless disregard. As long as we testify that we express a sincere belief, all is well. And that's simply not the standard. The standard is we can look at circumstantial evidence. And ill intent and motive are elements of circumstantial evidence. We're not saying, and I don't think the court below said that they have to be elements of the offense, but rather it is circumstantial evidence. And here we have a reporter who, well in advance of the reporting, viewed these people as anti-trans, called them, and subsequently called them bad actors, and whatnot. So there was substantial animosity towards my client before and after she wrote the article, and the court can take that into consideration. And why does that matter? Well, here if you look at the actual words that were used, that formed putatively the basis for this, we'll call it article or expose, they don't match at all what the what Ms. Dunn and what the report said. The language was that the media is really trying to spin this. That if any of your kids, so she's reaching out to members of Jeffco Kids First, would be willing to record anonymous audio. Well, that's anonymous audio. It's not recording video. It's recording anonymous audio. There's nothing in there about secretly recording, much different, of their experiences. In other words, the kids record anonymous audio of their experiences. What are their experiences? The ones that they've experienced with furries, hissing, barking, clunk chasing, and how it affects their day. So it's referencing the kids. And from that, that's essentially twisted. I would say it's almost unrecognizable when they say Ms. Datko urged kids to secretly record others.
How is how they're interpreting it not a reasonable interpretation when you have the article and it quotes the text of the Facebook?
So I think that's two different questions. So one is whether or not it's a reasonable interpretation. And we've provided basically a plain language analysis looking at the words. She asked for anonymous audio. They say, go secretly record video. Those are different things. They say of other kids, she's asking for anonymous video of their kid.
So you would say this language was not ambiguous?
No,
There's
not
only
at
one
all.
reasonable interpretation.
It's pretty darn clear, and it's certainly not what Ms. Dunn reported. So that's the first element. Your Honor, the second element you say is, well, they included the quote in the article. Let me step back. There's three statements. One was the stuff in the article. There was a tweet and an editorial. Just to clarify, the language was not included in the defamatory tweet, and it was not included in the defamatory editorial, both of which are at issue in this case. With respect to the article, simply including that language is not an insurance policy. The statements were false. They were defamatory. What they're saying is, well, it's the reader can make up their own mind. And there's a little bit of tension in their argument. On one hand, they're saying, well, what we said was reasonable. It's reflected what's there. And then the presumption is, well, it's not reasonable, it differs. But since that other stuff was there, they can make up their own mind, and it's not really defamatory. It doesn't really cause that defamation. But if you look at the article itself, they don't say, this is how we, and I noted very carefully that the appellant said, well, what the article said is this is what we characterize. They don't say that. They don't actually tie that into the quote and say, well, this is what the quote means, this is how we characterize it. So a reader could easily see, and I submit it's very reasonable for someone to say, they're saying, they're reporting, Ms. Dunn's reporting, that they asked to secretly record others. And then here's a quote up here that doesn't say that at all. I guess they must have something else. So they're not saying, they weren't reporting on that quote, saying that quote is, what that quote says is this. What they're saying is, here's a quote up there, but she said this, or and she said this, I guess is the proper way to characterize it. So it's not, the article is not, here's how we characterize the quote. The article was, this is what Lindsay Datko said, and then they also included another quote. So it's not saying we characterize the quote in a particular way. And I think that's a valuable point to understand. So when you look at actual malice, so the actual malice analysis looks at, and I think we sort of said this in our briefs, they're native users of English. They understand what words mean. We should presume that. The words that they claim to report on were much different than what they are claiming those words meant. So it was false when they say Ms. Datko said X, Y, and Z. Ms. Datko never said X, Y, and Z as they claim it. She just never said that. She never encouraged kids to take videos of their classmates. Now, the other thing I'd like to talk about, just to answer an earlier question, limited purpose public figure. I know you all denied our motion for cert reply, but I think it's nonetheless very important to say at the trial court the question was furries. If you look in their reply brief, the appellants, they sort of shifted things. They said, well, the controversy isn't furries. It's school reform is what they stand for, school reform in general. And then they go outside of the record and grab evidence of interviews from 1 and 2 and perhaps 3 years ago. I think it was 1 and 2 years ago on a completely different subject, which was COVID. COVID school lockdowns, kids wearing masks and not going to school. That's what that issue was, kids in school there. It wasn't school reform. In fact, there's no evidence they've ever talked about school reform. They're not saying let's get a new board of director, new board. They've not said the teachers need to change. They've not said the curriculum needs to change. They said, here, furries, kids should not be allowed to dress like that. And then a year and a half below, they talk about COVID. That evidence that they've injected here was not in the trial court below. It is completely and wholly inappropriate for this court to consider or for them to argue. Even if you consider it, though, although I'm confident you won't based on the case law. But even if you were to consider it, it doesn't make their case. The definition of a limited purpose public official, maybe we should just say LPPO, a LIPO, is in Lewis McGraw. They cite Gertz, the Supreme Court. Lewis McGraw, we quote as passim throughout our answer brief, is voluntarily ejects himself or herself or is drawn into a particular controversy and thereby becomes a public figure for a limited range of issues. So you have to be voluntarily injected into a particular controversy. The evidence is clear here that Ms. Datko and other members of Jeffco Kids First never wanted to have any public visibility with respect to the furries debate. They did not inject themselves into the furries debate. And it says a particular controversy. Look, they're not public officials. It's not like they're a controversial state official who fair game anytime you want to say anything about them. It's a limited purpose public official for a limited purpose. In other words, that controversy they have to inject themselves into. They did not inject themselves into the furries debate. And whether or not they were interviewed, and there's no evidence they even injected themselves into that debate. They were interviewed. Okay, they didn't run for the hills, but there's no evidence they voluntarily injected themselves. But let's say, we'll still use that framework for the moment. That was COVID, how it affected children in the classroom. Much different. Now the plaintiffs or the appellants try to tie this together in their reply brief, and they say, well, the limited purpose public, limited LPO is school reform. That's not the case. They've never advocated for school reform. The evidence shows furries. They talked about furries in a private group, which even Ms. Dunn recognized was a private group in her article.
Does it matter what the size of the group is?
There's
I
no-
know we've got 6,000 here, but let's say it's 100 versus 1 million. I mean, does it at some point become something bigger that might inject yourself out there?
Maybe. There's no case law on it. Look, I mean, Jeffco has a population of over 500,000 people. I think the court can take judicial notice of that, maybe almost 600 now. But around 500,000, and this was 6,000. It was a very, very small percentage of the population in Jeffco. I mean, by any stretch, that would be considered private. And I rarely use rhetorical questions in my oral argument, but I'll use one here. If it weren't a private group, why did Ms. Dunn have to impersonate and get credentials to get into it? Because she wasn't invited and she wasn't allowed in otherwise. She had to sort of impersonate, deceive people that she was a member to be able to get in. That was a private group, and it was monitored. If it's 6,000 people or 10 people, it is still considered private. A hotel is private, no matter how big the hotel is. It's still considered a private institution. So, and if you look at the newspaper article that was published, they said the private Facebook group. They actually characterize it as a private group as well. So I think they recognize that too. Let me go on to a couple points in my very limited time. There's an argument that the decision not to, or the non-comment. Okay, Ms. Dunn and the opponent say, well, we asked for comment, and that's true because 2 months before this controversy even came up, we wanted to interview him. It is not true. It is false based on plain language. Here's the plain language. Their comments, and this is our third claim, they said, neither Datko nor Gunnell responded to Colorado News' request for interviews about the Facebook group's activities, And then they later said in the article, we sought comment from group leaders who did not respond. Why do I emphasize those words? Because if you go to the July 25th email request, that's CF259 to make it easier to look up. This is what Ms. Dunn said. She says, I'm a reporter with Colorado Community Media working on a story about Jeffco Kids First. My hope is to sit down with you and get a better understanding of your position and what you're advocating for. And then here's the money quote. I want to clarify off the bat that I am not looking to do anything other than write an explainer about what the group is. That was her request. Her request was not for comment, which implies a reaction to a story. That was not her request. Nor was her request about the Facebook group activities. It was about Jeffco as an explainer, Jeffco Kids First, which is not just a Facebook group. Yes, ma'am.
If I could interrupt you for a sec. I know that the trial court combined the analysis for libel per se and libel per quad. On that issue, that third claim, the libel per quad, where is the... You talked about material falsity, but where is the actual malice that you're trying to prove just for that third
Based
claim?
on the plain language itself, Your Honor.
With respect to...
Right.
Okay.
With respect to the appellants, used the words, we asked for comment. They lied about it. They didn't ask for comment.
But
They
where's
didn't
the
ask for
malice?
reaction. I'm sorry?
Where's the malice, the actual malice?
That's intentional. You're intentionally distorting the words. That evidence itself is adequate. And I would secondly say, then Ms. Datko spoke on this November meeting with Ms. Dunn and one of the editors and said, look, we never got this. We never got a request to comment on the story. And then the newspaper doubled down on the same thing, again, making a false statement. They knew what actually happened, but they nonetheless made the false statement. Yes, ma'am.
I didn't have a question.
Oh, my ears are twitching. My apologies.
So, counsel, just so I can clarify, it's your position then that just looking at the words and if they are false, that's sufficient to show actual malice?
Likely, yes, but we're not only relying on the words here. There is additional evidence on all of these items. The actual, the animosity, that infects the third claim as well. I mean, there's still some animosity, and it is a desire to paint this group in a very poor light. So how do you paint them in a poor light? Well, you say, we asked them for comment. They never spoke to us. Therefore, an implication of their guilt, because they refused to come clean, paints them in a poor light because they wanted to do that. So that does infect the third. Yes, ma'am.
Sorry. Could we talk about the second claim then? Again,
If I have enough
the
time,
libel
yes.
per quad. Okay. So, in essence, you're saying that the posting told people to go to TikTok and to harass furries or something like that. That was the gist.
Yes.
So, again, based on just that claim, how do you prove actual malice and falsity if the TikTok videos were posted 6 months before the article came out?
Again, circumstantial evidence. Okay, so let's be a little bit clear about exactly what went on with the timeline here. Kyle Clark says furries are debunked hoax on September 27th. That riles people up. They're trying to prove that that they're not a hoax. One of the commenters says, just go to TikTok. You'll see that furries exist. All right, so what does Ms. Dunn do? She goes to TikTok. She pulls something from TikTok completely unrelated to Jeffco Kids First. Jeffco Kids First never posted that on TikTok. That wasn't part of Jeffco Kids First. What does that say? Well, it's incendiary. Kill furries. And how does it appear in the article? I suggest you take a look at CF 258. It says, on the third page of that article, it says, Jeffco Kids First. An image, kill furries. Next to that, it has Ms. Datko's quote. And in fact, if I may take just a few more seconds to
You can finish
answering.
responding to the question, yes.
Okay, thank you. And if you look at the article, the way the article is structured with a logical approach, it says, Ms. Datko posted a request for information. Now, the request for information she posted was for anonymous video, which is different than the Kyle Clark one. Kyle Clark comes September 27th. Then people are trying to provide evidence. And then on the 28th, she asked for anonymous audio of kids' experiences because the ground has shifted. Well, they may exist, but they're not a problem. You look at the suggestion, and that was from Ms. Dortch, and we have an declaration from Ms. Dortch saying, look, I was responding to the very first one. And what that said was, and I was saying, hey, if you look at it, she was responding to someone and said, does this really exist? Yeah, go to TikTok, you'll see it exists. That TikTok post was not from Jeffco Kids First. But what the story says is, well, she posted this request, Ms. Datko, a different one than what's reported. Someone said, go to TikTok. I go to TikTok, and there it is. People, and Ms. Dunn was very clever on this one. She said, it appears to be people who were recorded anonymously. I don't know how you get that from a photo. So she adds that flavor to it and says, and here it is, a post of kill furries, right next to Jeffco Kids First. Our complaint the verified complaint referred to the online version, which said inside Jeffco Kids First, and then had an uncaptioned photo immediately below it that said kill furries. So yeah, even you, Your Honor, think, oh, well, Jeffco Kids First posted kill furries. No one from Jeffco Kids First did it, completely disconnected. But even you, and I would say the reasonable reader, thinks that Jeffco Kids First did that in response to Ms. Datko's request. That's false, it's defamatory, and it is used to trash my client. My time is up. Thank you for your indulgence.
Thank you, counsel. Let's add 2 minutes to the rebuttal time here. All right. Thank you, counsel. You've got a little over 6 minutes.
Thank you, Your Honors. I will respond to just a few of the points that Mr. Gessler made. First, with respect to actual malice, he provides a word-by-word careful dissection of the post and says that Ms. Dunn and my clients got it wrong. And that's falsity. That's not actual malice. And that would be falsity if the article didn't include the actual text that it described. And Mr. Gessler suggests that the text might have been the characterization in the first paragraph must have led a reasonable reader to believe it was some other text, not the one that's published on page 248 of the record in full, bearing a caption that reads, this above is the screenshot of Datko's post in Jeffco Kids First asking parents to have their children record classmates. That's the only post. And that's the caption. That's what it's very clear to a reasonable reader is being characterized. This post above this caption is the one in which we believe she's calling for that. The first paragraph says that she called for parents to record kids, and then the next sentence reads, quote, if any of your kids would be willing to, and basically recites that post. And then on page 245, again, one of the claims they say is false was last month, Datko urged nearly 6,000 members of Jeffco Kids First to have their kids secretly record their classmates. Next sentence, quote, the media is trying to spin this, Datko wrote in the post, meaning this post that begins, the media is trying to spin this. If any of you kids, this is the only post that any reasonable reader could understand was being characterized. As to actual malice, I would point to page 28 of our opening brief, a case called Michael versus New York Post, NYP Holdings, where the 11th Circuit said, reporting perspective contrary to the publisher's own, meaning the note that was appended saying Ms. Datko disagrees with our interpretation of her text that we've provided for you. So reporting perspectives contrary to the publisher's own should be interpreted as helping to rebut, not establish, the presence of actual malice. If my clients had wanted to misrepresent what Ms. Datko had said, they would not have provided her text and her interpretation of it to the reader. Lastly, I want to spend just a second or two on a limited purpose public figure because it bears that. Mr. Gessler says that Ms. Datko and her group were not limited purpose public figures only for the purpose of discussion of furries. He can say that all he wants, but the article's not about just furries. The article's about Jeffco First and how it's been lobbying the Jeffco public schools for years, including with respect to the pronouns policy and trying to stop use of any type of, I don't want to say, but your honors have the article in front of you. She's a limited purpose public figure, and her group is as well, because they had for years lobbied. And I'll just read Mr. Gessler's own words, paragraph 20 of the first amended complaint, page 194. Datko advocated for the entire school district to adopt the Drake Middle School policy. Specifically, on August 18th, months before the article, she wrote in the Jeffco Kids First group Facebook page, if just 100 of you email the list below, see top of comments, and ask them to ban ears, tails, furries as district-wide policy, we might see this happen. Email your schools as well if this is an issue for you. See policy comments as well. Mr. Gessler said there was no evidence in the record below as to advocacy by Ms. Datko and her group on other issues regarding district policy. I turn your honors to pages 225 and 226 of the record, specifically footnote 11. In our motion for special motion to dismiss, we pointed to Ms. Datko's posting on October 1st, commenting on Governor Polis's failure to take seriously disruptions in schools. We pointed to an iHeartRadio interview that Ms. Datko gave in 2020 and in July of 2026, talking about child care mask mandates in 2022, and an appearance by Beth Parkinson, the co-founder of Jeffco Kids First, in 2021 on the Ross Kaminsky Show. The reason we added additional citations, and I bring this to the court's attention, is because we did call out plaintiff's counsel, not the plaintiff, for standing before this court and stating that this group has steadfastly, assiduously sought to gain any public attention. I believe that's sanctionable conduct, and I ask the court to take that seriously. Look at what is in our reply brief. Look at the body of evidence that they are pretending doesn't exist and are knowingly, willfully misrepresenting the record evidence, both the record evidence and what the court can take judicial notice of on appeal. what is on the internet. Shook versus Pitkin County Board of County Commissioners, 215, Court of Appeals 84 at paragraph 12, note 4. And in 2024, COA 97, Bennett versus Colorado Department of Revenue. And lastly, a 2014 case called Hanlon versus Gessler. That's a 2014 COA 24, paragraph 22, note 8. I ask the court to take judicial notice of the voluminous evidence that these counsel have misrepresented to this court. Thank you.
May I respond to the request for sanctions? I find this stuff distasteful, but I may have an opportunity.
Sorry, let's say this. If you want to request sanctions, let's not do it here during oral argument. If you want, you can file a motion. You can appropriately take the time to respond to that. If you want to file something like that, let's say you do it within 7 days. I'm making sure my colleagues are okay with that. And then you'll have the appropriate amount of time under, let's say, 7 days to respond if such a motion is filed. Okay, thank you, counsel. The case now stands submitted. An opinion will issue in due course. Thank you, counsel, for your arguments today. With this, that's the last of the 3 cases on our docket. So that concludes our oral arguments for the day. The court will be in recess, and the bailiff may so announce.